in Toronto and soon realized the error of his ways. He then went to Ottawa, where in 1963 he formed the firm of Nelligan Power. He's extremely active in many professional organizations. I won't go through each one of them. Suffice it to say, he is a past president of the Advocate Society. He is also a fellow of the International Academy of Trial Lawyers. But I suppose most importantly, he's one of the leading trial and appellate lawyers in Canada. I can tell you that you will soon be reading a judgment of the Supreme Court of Canada in the case of Angus and Son. It's a case that deals with whether or not provisions of the Insurance Act are retroactive. It was a case where the insurer lost at trial, the insurer lost at the Court of Appeal, but through some excellent advocacy on the part of John, the insurer was able to obtain leave from the Supreme Court of Canada, which is a very rare event in insurance cases these days. And having achieved that, he was then successful on the appeal. I really wanted John to come and speak about that case, but unfortunately it deals with a section that isn't entirely isn't that significant today because of the it dealt with a specific period of time when the policy was alleged to be retroactive. I persuaded John, I think, to, over his better judgment, to speak today to you about limitation periods. When I first raised the question with him, I think he felt there was really very little to say. The limitation periods were spelled out in the Act and the policy, and those were usually simple matters. I asked him to at least address the subject and speak to us very briefly then about them. I think when he started to look at the policy, he became somewhat exercised, and we have to try to cut him down to half an hour to speak to you on the subject. But I'm sure that you will not only find John an interesting speaker, but the substance of what he has to say about limitations will at least be stimulating and informative. My pleasure to call now on John Nelligan.
Thank you, Wendell. I must confess that I come here as a student rather than as a teacher, and I think Wendell put me on this subject deliberately to try and work up some reforming zeal in people outside the insurance center here in Toronto, because the difficulty with limitation periods is none of us in this room really worry about them because we're always prompt in getting our action started. Once the accidents happen, the writ goes out within the week kind of thing. But even in defending actions, sometimes we wonder how slow other people are, but it's with respect to one particular situation. It's only when you look at limitation periods in a general context that you become appalled at the lack of logic and the lack of a system. I had thought in my innocence that limitation periods were one thing that we were starting to simplify. We were trying to put in general patterns so that the citizen let alone the lawyer, would understand that he's got to act reasonably promptly so that the other side isn't prejudiced. But when you come to the insurance policy, you find it's not only a question as when does the clock run, but what speed is the clock set at, and who sets the clock and who reads the clock. We find that in this Hall of Justice for insurance, we've got different clocks, or like a clockmaker shop, all ticking at different speeds and the hours sounding at different times. And it's no consolation, like Peter Webb, to say, well, keep a copy of the policy in your drawer, because I started to read the policy and I found that it's like a sandwich. The limitation period for the first item is mentioned last, and the second item is mentioned second last, and the third item is mentioned first. And just as an example, if you want to take the policy that's at the back of your book, because having been advised by Peter that you should read that policy, you got to see how we flip around, because you look at Section A benefits, which Peter spoke about, and that's on the first page. So you say, well, when do I sue? So you go to the last page. That's page 15. Limitation of actions is on page 15, and that relates to Section A benefits. Now, it comes under a section that says statutory conditions, and you'd expect that they applied to the whole policy. But when you look at the first part of the statutory conditions, it says, with respect to Section B only, statutory conditions 1, 8, and 9 shall apply. And it turns out that the requirements for both notice and limitation of actions don't fall within those sections. So you say, well, let's turn to Section B. Well, Section B is on page 2. Good. Where will we find the limitations? So you look on page 7, and it says special provisions, definitions, and exclusions of Section B. Great. So we look at notice provisions. They're on page 8 at the bottom of the page. We look on page 9, subsection 7, and there are the limitation periods. So now we've got Section B down. Not quite, because then we look at subsection 3 of subsection B. We're now getting down into uninsured coverage. And if you look at subsection, that's on page 4, you flip over to page 7, and it says, section 11.2, special provisions, definition, and exclusions of Section B of this policy do not apply to insurance provided by this subsection. So it's carved out a different way. So you start to grope around and you find that notices now are at the bottom of page 6, section 7, and the limitation period is on page 7, section 9. So it's not really an easy question of reading. And of course, I have another problem with all of the uninsured benefits, because they've been shoved in under accident benefits, and it says the insurer agrees to pay to or with respect to each insured person as defined who sustains bodily injury or death. And then when you come to subsection 3, it says all sums that a person insured under the contract is legally entitled to recover, and so on. So I'm not even sure whether you can claim uninsured benefits unless somebody's been injured. But apparently nobody's faced that problem. There's a tacit consideration that that's all an embarrassing mistake, and we shouldn't pay any attention to the first part of subsection 3, and you should just look at the rest of it. Now that's the spirit in which you start trying to interpret what limitation periods there are. And it breaks down then into a different thing, is that while notices are not necessarily as severely enforced as limitation periods, there are requirements with respect to notice. And those requirements, just like the limitation periods, vary in their intensity, in their direction, and in their place in the policy, so that you have to be very careful that you've given the proper notice at the proper time to the proper people. Plus the fact that some of the things that we're going to talk about aren't even in the insurance policy. Some of them you have to look to the Insurance Act. And in others, you have to look at the case law, and in the case law, the judges admit, well, they really didn't cover this in the policy, and we have to do something, so this is what we think it should be. So you see how easy this is and why I was only given 15 minutes. Well, let's take the easy ones. The third-party liability that Peter Webb talked about under Section A. And that provides that when an insured is involved in an accident involving loss or damage to persons or property, you must give written notice with all available particulars of the accident promptly, whatever that means. But it's in the policy. If the insurer denies coverage, then an action against the insurer must be commenced within 1 year next after the cause of action arose, and not afterwards. Well, in this case, one would assume that the cause of action arises when they deny liability. But again, that seems to be reasonably straightforward. But you then get away from the policy, and where you get the third party trying to sue on the policy, as was described by Ted, where an action has been commenced against an insured and a judgment obtained, the third party must bring its action against the insurer for any such judgment within 1 year from the final determination of the action against the insured, including appeals, if any. So that's in the Insurance Act. And if you are going to sue the defendant's insurer, then you must bring that action within 1 year of completing your proceedings against the defendant driver. Now that's relatively simple. You go on to collision damage. Collision damage is, and of course, in Section C, but it also falls under the statutory conditions limitations, but within the very same clause that said that you bring your action within 1 year after the cause of action arose. Here it says you bring your action within 1 year after the happening of the loss. So if you're claiming for collision damage under Section C, you must start your clock from the date of the accident and not from the date of the denial of coverage. One more variation. Then we come to accident benefits. Now, when anyone has sustained bodily injury and suffers thereby, Ted has told you that you have a claim and you must notify the insurer, this time within 30 days from the date of the accident, not promptly, 30 days, or as soon as practicable thereafter. Then, if there's denial of coverage, you must commence your action against the insurer within 1 year from the date on which the cause of action arose. There seems to be some magic interpolation, 1 year and 2 year. I'm not quite sure where the 1 year has a value over the 2 year, but they seem to like to use the two periods quite regularly. Now, on that particular situation, in the Zaguras case, which just came down this year, it says that the 1 year, if there's a denial of coverage, the insurer has 30 days to pay after you filed proof of loss, so the year doesn't run until that 30 days is expired. So you basically have a year and 30 days from the date you file your claim. Now, I've skimmed over these things because there hasn't been much litigation on them, and the policy is there and it speaks for itself. But when we come to the uninsured motorist cover, which has been inserted into the middle of the accident cover for reasons which escape me, we find that the periods are more convoluted and the courts are more confused, and as a result, we have to really look at both the policy and what the courts say. Now, what does the contract say? The contract says that where there is an unidentified vehicle, we've got two situations, of course. You've got an uninsured automobile and you've got an unidentified automobile. And we have to keep these two clear in our minds. Where there is a hit-and-run case which caused bodily injury, the accident must be reported within 24 hours or as soon as practicable thereafter to a police officer, and a statement must be filed with the insurer within 30 days. Now, where there has been a legal action commenced against any person operating a motor vehicle where there is to be a claim, you must send a copy of the writ to the insurer. Where a claim is to be made against the insurer under the uninsured motorist cover, the insured must give written notice to the insurer within 30 days from the date of the accident, or as soon as practicable thereafter. And then, with regard to all of these, they have the broad general condition that an action must be commenced against the insurer and must be begun within 2 years from the date on which the cause of action against the insurer arose. So we're not talking now about 2 years from the date of the accident. It's against when did the cause of action against the insurer arise. Now, these statutory conditions, which are in the policy, of course, are drafted by the superintendent of insurance in collaboration with the insurance industry. But they have as their theme a limitation period in the Insurance Act itself, which says that any action against an insurer with respect to these type of claims shall be commenced within a limitation period specified in the contract, but in no event shall a limitation period be less than 1 year after the happening of the accident. So that's another variation, but that was a minimum period, and the policy has extended it beyond that. Now, all of this, which I've rushed over quickly and shown you were in the policy, has resulted in a series of cases in the courts trying to figure out a consistent policy with regard to limitation periods. We've had them going on now for some 5 years. The first case that I refer to in my material is a question of prematurity, because we have a dual problem, which was mentioned by Ted, is when is it too soon to bring in your insurance company, and when is it too late? And so we have the rather silly situation of sometimes the insurer pleading to come into the action, and in other cases trying to reject its intrusion into the action, and the court's trying to work out a policy where they define when an insurer can come in of its own, at its own request, when it can come in at the assistance of the insured. And in Waterloo and Zubrig, we had a case where the defendant filed a defense, but his insurer denied coverage. And the insurer of the plaintiff's vehicle quite naturally was interested, as Ted pointed out, in coming in and making sure that a fair and reasonable judgment was obtained. And in that case, they held that where there was a contested action, barring some other defense, the insurer is obliged to pay upon the judgment against the defendant, and the cause of action only arises on refusal to pay. So that was in 1983. In 1986, we had the case of July and Neal. And this was a question of an unidentified driver. Now, it seemed clear that if you were hit by a hit-and-run driver, you should notify the police, notify your insurer as the requirements stipulate, and then go against your insurer. But in this case, there were 2 vehicles, 3 vehicles in all, involved in the accident. And the known driver pleaded in his defense that he wasn't responsible for the accident at all, but an unidentified automobile had been the sole cause and was solely responsible for the accident. Well, by the time the defense was filed and the defendant was examined for discovery, the 2-year period from the date of the accident was long past. And the question then arose was there then a claim against the plaintiff's own insurer? And there was a long analysis of the policy by the late Associate Chief Justice McKinnon and by Mr. Justice Morden. in which they conceded that this, using McKinnon's language, was a casus omissus. They just hadn't contemplated a situation where you would have both an identified and an unidentified vehicle involved at the same time and have to determine when the action would arise against the insurer. In any event, in that action, they came to the conclusion that you had to have your 2 years, you couldn't have a 2-year period expire without you knowing that you had the cause of action. And therefore, they set the condition, if I may read it here, time begins to run when the material facts on which the claim is based have been discovered or ought to have been discovered by the plaintiff by the exercise of reasonable diligence. So that if you know from the outset that it is the unidentified driver who is solely responsible, then you should commence your action immediately. If you only discover it in the course of your pleadings and examinations for discovery, then at the stage when you should have known it, then you should join the insurer, sue the insurer. The problem, of course, is that with the 1% rule, as long, in my view, as there is a reasonable probability that the identified driver is going to pick up at least 1% of the blame, can it be said that your cause of action has started to arise against your own insurer on the unidentified vehicle provisions? And they didn't quite decide that. They simply said this is a matter which should be left for the trial judge and that the insurer could be added. Now, Morden wrote a very full ancillary judgment, and he said that the rule was essentially a question of fact. When did it, or reasonably should it, have become apparent that the unidentified driver was solely responsible for the accident? Now, he was satisfied that legislative amendment was required, and he pointed out that there is a very delicate question of costs here. What happens when the plaintiff unnecessarily joins his insured? How do you allocate costs when, out of an excess of caution, you bring in too many parties because of the very remote possibility that the unidentified vehicle will be found totally responsible and there'll be no blame attached to the identified vehicle? Well, that was the one approach, so that you start your clock running from when you have reasonable evidence available that the cause of action is solely against an unidentified driver. The next permutation was in a case a couple of months later, which got to the Court of Appeal, called Johnson and Wunderlich. And in that case, there was a known driver. He was sued, but he failed to defend. And by the time the plaintiff moved to join his insurer, more than 2 years had expired from the date of the accident. Now, it was interesting in that case that in the Court of Appeal, the Minister of Consumer and Corporate Affairs actually intervened and tried to tell the court what was meant by the legislation. And at least they suggested that they knew what they were doing when they drafted it. Morden, in his judgment, accepted largely what he said, but we get now the anomalous situation. He suggests that you can sue the known driver and wait till you get judgment and then claim over against your insurance company. You can sue your insurer alone and get a declaratory judgment at the beginning, or you can join the insurer even though you haven't got a judgment yet and get a declaratory judgment even though the 2-year period has expired from the date of the accident and the cause of action arising out of a judgment hasn't arisen yet. And so we've got sort of this amorphous situation where an insurer was not allowed to come in prematurely on his own request, but the suggestion that the insured can bring the insurer in for a declaratory judgment even before the action against the original wrongdoer is completed. Frankly, it's a real mess. Finlayson proceeded to write in another judgment, putting it all on the basis of contract and saying that there is no contract liability until there is actually a judgment. And if you look, of course, at the language of the section, you pay all claims which you, all sums of money which you are entitled to receive from an uninsured motorist and so on. And therefore, he took the position that limitation periods don't seem to run at all until you've got a judgment against this identified but uninsured vehicle. Rushing on, because there's still more to cover, we get into the underinsured coverage, which was first given under SEF 42 and now is under SEF 44, and that will be discussed this afternoon. But this is optional coverage, and therefore is not to be found in the standard clauses, but is in the special endorsement. And when the underinsured coverage first went in, they had a very simple limitation period. They provided that an action was to be commenced within 1 year from the date when the cause of action arose. And that was determined by Mr. Justice Gray in the Peltier case, that the year arose when the insurer refused to pay the unsatisfied judgment. Well, within the year, SEF 42 was out and a new condition was put in, and you will now find that in all policies since 1985, they require notice, prompt notice of every accident, and the insurer must be advised of any action brought against a third party, and you must commence an action against your own insurer under this special endorsement within 12 months from the date upon which the eligible claimant or his legal representative knew or ought to have known that the quantum of the claims with respect to an insured person exceeded the minimum limits for motor vehicle liability insurance. No action which is commenced within 2 years of the date of the accident shall be barred by this provision. So now we've got a very special clause that says as soon as you have any suspicion that there's going to be a claim under this, you've got 12 months to begin your action, but as long as you begin it within 2 years of the accident, you're okay. Now, it's just one more complication in the whole mess. I think with respect that if this clause was put in with them all, we'd be a lot better off. Now, one further little, not twist, but warning. Wendell has mentioned the Angus and Son case, and there was an indirect reference in that to limitation periods, because in the July case, McKinnon pointed out that this was a matter of contract, of course. He used the contra preferendum rule against the insurer and said that even though they didn't draft it and it was a statutory condition, that because they participated in the drafting, if there were two possible interpretations, you would interpret it in favor of the insured. And Finlayson, again, in Johnson, points out this is purely a contractual requirement, and therefore, under the strict terms of the contract, limitation periods don't arise until there's an actual claim to be made. Well, in the Angus case, it was basically the application of the Family Law Act reforms as to the rights of wives to sue husband, and Nelligan, in the goodness of his heart, decided that because the wife could now make claims against her husband, generally you could ignore the provisions in the insurance policy and give her an award under the insurance policy as well. That's, briefly, is the thrust of it. But the court had this to say at the end, having found that those family law provisions were not retroactive to a policy. It said, the case is a good illustration of policy reasons why statute should not be given retrospective operation in the absence of an intention to do so that is either expressed or necessarily implied by the statute. Substantial rights of insurance companies are affected by the decision of Nelligan. The reasoning regarding limitation acts applies a fortiori to the situation of insurance companies, and this is why I'm bringing it in. Insurance companies calculate their premiums according to known risk factors, and then points out that they had issued the premium on the basis they wouldn't have to pay for wives who were injured. In Martin versus Peary, this court held that the change of a limitation period for medical malpractice actions could not be given retrospective effect, since physicians could have relied on the older provision to order their affairs in such a way that they would be prejudiced by the change. The analogy here, in my view, is clear. So what I'm warning you is that if these legislative changes do come in, as have been pleaded by the courts for the last 2 years, you still must be very careful, because a legislative change will not, in the absence of very clear language, affect the change in the policy which was in effect at the time the accident occurred. So you always must go back and look at the language at the time that the original cause of action arose. So let me try and summarize. What should we do? I think that the basic thing is you've got to keep your insurer informed all the time. You have to sue them or invite them to join promptly. In the case of an unidentified automobile, where the accident is caused solely by an unidentified automobile, you must sue the plaintiff's own insurer within 2 years of the accident. Where an identified driver pleads and an unidentified driver is solely responsible, move to join your own insurer immediately, but in any event within 2 years of learning of the defense. When a defendant fails to defend and is uninsured, it's wiser to join the insurer within 2 years of the default. Where the defendant defends the action but his insurer denies coverage, it's premature for the insurer to move to be added, but question whether the insured cannot add him, seeking declaratory relief. Where defense is entered, time begins to run when the insurer defaults in paying the original in judgment. And then, under the underinsured motorist coverage, you must join your insurer within 2 years of the accident or within 1 year of learning the possibility of inadequate insurance. But the golden rule surely must be, always make sure you have a contested action, always keep your insurer informed, and when in doubt, join your insurer. Thank you.
All I can say is that John has agreed to sit on the panel this afternoon. Please be sure to get any questions you may have in writing and delivered to us before the panel. The next speaker is Allan Houston. He is a senior partner in the firm of Paroyan, Raphael, Curry, Cohen, and Houston, with offices in Toronto and Windsor. He is a past president of the Advocate Society. He is the senior litigation counsel with his firm. He's a frequent lecturer at the University of Windsor, the Law Society of Upper Canada, and the Medical Legal Society of Essex County, Canadian Bar Association, and the Essex Law Association. You will frequently see his name in the law reports. Unfortunately, they all seem to be with respect to the same case that has been going on for several years. No doubt he will mention this case. They seem to litigate it in Michigan, and when they get through there, they come back and litigate in Ontario, and then they go back and litigate it in Michigan, then come back in Ontario. In fact, I think there was a note of another judgment in the case yesterday. So I've asked Allan to speak to you with respect to coverages outside of Ontario. His paper seems to be erroneously entitled SCF 27, but it just indicates how he can take a simple endorsement and expand it into a 20-page paper. I call on Allan Houston.
I'm going to speak about the Travelers and McDonald case today. I was kind of hoping Ken Howie wouldn't show up until a little later, but I see he's here now because Ken and I tried the main action, and I was going to say some things that I didn't want him to hear. I'm going to say them anyway, but I'll use another name. When I use another name, I'm speaking of Ken Howie. I also like to tell you that thank you very much for the introduction, Mr. Wigle. I've always thought of Wendell as my dad. Wendell's old enough to be my dad, and he's always been very supportive until I got into this Travelers case. Since that time, Wendell and I have not spoken much, and I think it's because Wendell didn't get a piece of any one of these 4 or 5 actions that have gone along. I asked him that a few moments ago, and he denied that, but I think that's the reason. Now, I also, as I was sitting down here this morning, can I move this up? I guess I can. Sure. How do you do that?
Just push the whole.
We're now going to see what he's very good at. Oh.
Complex things are different.
When you get older, you get very wise in these areas, and so. When I was sitting down listening to Peter and Ted speak this morning, I was very impressed with their knowledge and understanding of the insurance problems that they addressed. And they stood up here in their 2-piece suits with their ties and so on. I've traveled with these people, including Wigle and including John, and I've seen them in short pants, and I've seen them in many different ways than you've seen them, and they are not stuffed shirts as they appear to be here today. They all drink a lot, but I'd like to tell you that, without mentioning any names, but not excluding anybody from this morning at all, that when we were in Hong Kong, Ted Racklin, who is very straight and very firm in what he says, presented to me, and I can't understand this, he presented to me at an event a Hong Kong wig with great aplomb and ceremony, and it was a full head of hair that was presented to me at this event. And I thanked him for it very much, and I was a little disappointed that he'd done this because I thought it was fairly insulting. I have no need for any additional hair. But I became happy when I found out a little later he'd paid $150 for it, and if you can get $150 out of Ted Racklin, you've done very well. Only, Peter, Peter, not to leave you out. Peter and I were in Africa together, and Peter looks pretty funny in short pants, and he wore them every day. We had a good time over there, but Peter, I was wondering, you see, I don't have a top drawer in my desk, and I was wondering what the option was for keeping an insurance policy if you didn't have a top drawer to put it in. Maybe they'd have to find someplace else. All right. That's enough with the humor. I come from the city of Windsor, and I'm a Detroit Tiger fan, and that's always stood me very well when I come to Toronto. Before you get mad at me, I have 4 box seats, and I can be talked to during the season, so don't insult me, and maybe we can do business. Can I take you then to what I'd like to talk about, which is the Travelers and McDonald case that Wendell referred to, and I wanted to take you to page 8. I believe it's 8 of the material you have in front of you. E. E is in Edward, 8. This is a case, I should tell you, and I'm sure a lot of you know, everybody has to be famous for something. I can tell you what I'm famous for. This one case, Travelers and McDonald, has now been reported in the Ontario reports 4 times. We're going to get it right eventually as we go on here, but we've now been reported 4 times on 4 separate issues, and we got another judgment the day before yesterday, which Ken Howie said we were going to win, and he was right, and we were able to lay off all of the Travelers exposure on the Michigan Catastrophic Claims Association, which I'll speak about in a moment. Lynn McDonald was involved in an accident in Detroit in a budget rent-a-car. You see, I don't think Wendell speaks to Ted Racklin because Ted Racklin had a piece of this action, and you didn't. Ted was involved in that first stage. She was involved in an accident in Michigan, and a certificate had been filed by the Ontario insurer Travelers, so that if their insurers were operating in the state of Michigan, their no-fault coverage would apply and not ours. The difficulty is that if you're a passenger in a car in the state of Michigan, you go first to your own carrier for your no-fault benefits, which, by the way, are unlimited in respect of home care costs and that sort of thing, and are limited in respect of wages, not to $140 a week, but right now it's just over $2,400 a month with a 3-year ceiling on them. In Ontario, your policy responds if you're the policy on the vehicle. So we had a direct conflict then as to which policy should respond, the budget policy, which was general accident, which was Ted's insurer, or Travelers, which was my insurer, who insured the passenger Lynn McDonald's father. Now here, Travelers said in Toronto, it is a named insured in their policy as an occasional driver who's a passenger in a budget motor vehicle in the state of Michigan when she is seriously injured and they're being called upon to pay. It defies all of our ground rules here. So I, being the very bright lawyer that I am, commenced an application here before Mr. Justice Saunders for a determination as to who paid. And I argued it brilliantly and at length, and I lost. I was not to be, and that's the first reported decision, and I paid costs. So I appealed. I do that often when I lose. And I appealed, and we got before Mr. Justice Zuber in the Court of Appeal, and then Ted showed up because now it was getting serious, you see. And we had an argument for a day and a half, and I lost again, and I paid costs. Mr. Justice Zuber said, what you did, Travelers, and all insurers in the province of Ontario, when you filed the certificate with the state of Michigan, what you did was you expanded your policy coverage to include the Michigan scheme. Now, throughout this whole period of time, I had Ken Howie hanging around because he represented Lynn McDonald, and he had a tortious action, and he was looking for me to do a lot of paying. So we lost at the Court of Appeal. Then we came back, and that's the second reported decision. Then we had a trial before Mr. Justice, and I think that's the next one, Osler. And we talked about a lot of things at that trial, and I commend that case to you for the purpose of looking at the things that are going to be covered. Let me take you to page 13. E13. I might indicate that we were going to arbitrate this. We had, in fact, set up an arbitration process, and we were going to arbitrate it. We got cut off by the Michigan Catastrophic Claims Association the day before the trial. Bob Montgomery was going to arbitrate it under the Arbitration Act. So we could not arbitrate it because they wouldn't agree. What we did then was we laid over, I believe, one day, wasn't it, Ken? They found another judge, Mr. Justice Osler, and we started the trial. And look at the items that we talked about. Lynn McDonald wants to come home. She's a quadriplegic. She's fed through a stomach tube. She communicates through a computer. She wants to come home. She did come home. Do we have to pay that? Yes, we have to pay that. What are our limits? None. Medical necessity? Not even that. Necessity for her care. What are we talking about? We're talking about buying a van. We're talking about paying members of her family to look after her. We were talking about the daily operating costs of the home. Excuse me. We were talking about equipment that she would need, which is quite extensive. And that trial went on for a couple of months, on and off, a couple of months. We argued it fully, and the reasons for judgment addressed the problem of what we were obliged to pay and what we were not. And I can tell you it was a lot. Questions like, when you renovate a home, how much of that should the no-fault carrier have to pay because there are other people living in the home? They didn't have a home, she had to buy a home. Should we pay for the home? Should we lease the home to her? Should we buy it outright and give it to her? What should we do about that? Should the father and the mother and the rest of the members of the family, should they look after a part of it? Should they pay half the operating costs? Should we pay them all? How about a burglar alarm system? Should we do that? Should we not? Round-the-clock nursing care, is that a fair thing to ask the insurer to pay, or is something less than that required? All of that was litigated, and Mr. Howie beat me up pretty good and did a very good job, and he got from us a fairly healthy judgment of about $16,000 a month till she is 65. Her life expectancy, I think, is 38 years or 40 years. So it's a lot of money. That was reasonably disappointing. And we had to pay costs on that very lengthy trial. I think that was the only thing we didn't have any trouble settling, wasn't it, Mr. Howie? Mr. Howie is very easy to deal with in respect of costs, as long as you're paying and as long as you're paying well. So we did that. And that's the third reported decision. And you should have a look at that because it's very helpful. Mr. Justice Osler wrote well, in my view, in that respect. I can tell you that we're talking about, as you heard this morning, excess coverage. We were, I think, 5 days into that trial, maybe longer, when it just dropped out of nowhere that Confederation Life had a policy that she was an insured person under and had some of the same coverages. So we stopped the trial. We chased it down. Very brilliantly, I moved to add them as a party defendant. Might surprise you that they showed up and said, "You got to be kidding. You're 5 days into a trial that's been going on for 3 years, and you've got to be kidding. We're not coming into this trial." And they did not, and they were ordered not to come in. Whether that was good or bad will remain to be seen, because that's the subject matter of another piece of litigation that we have going right now as part of this ongoing saga to see that our people pay very little at the end of the day. That's still outstanding. So we lost that trial. We did not appeal that decision. And then we added the Michigan Catastrophic Claims Association, which we'd added early on as third parties. What they do in Michigan is that the first $250,000 is paid by the insurer who writes the risk. The balance is paid by all insurers who write insurance in the state of Michigan or who offer coverages in the state of Michigan in accordance with the number of policies that they wrote last year. Now, so I wrote them and said, listen, we have this claim that's probably going to exceed $250,000. Maybe you'd like to send over a check. And they didn't want to send over a check. And in fact, they kept saying, "Who are you?" And I kept telling them who we were, but they said, "Well, you see, you're not licensed to practice in Michigan, at least to sell in Michigan." So we added them over here as a third party. That third party proceeding was heard, and that judgment came down the day before yesterday and said that the Michigan Catastrophic Claims Association is obliged to indemnify Travelers Indemnity Company of Canada for all claims in excess of $250,000 that we have to pay to Ken Howie's client. Now, that's just as fresh as a couple of days ago, and it's a very well-reasoned judgment. Where it's going from here, I don't know. But that really takes the bite out of what is the value of the insurance premium on med pay, maybe $20, $22, something like that. And the payout today is probably in excess of $1 million. Also, the $25,000 limit that you're talking about in our policy is gone by the board. Because once you incorporate the Michigan no-fault, there you are. Every insurer has filed this certificate, not only in the state of Michigan, but in a lot of the United States. And so you must be very careful if you're litigating. You must be very careful if you're an insurer, because you have a risk out there that you can spend a lot of money defending and paying. I will tell you that in the course of that trial, there was an allegation of bad faith as against Travelers. for not timely paying the premiums and so on. And that was fully argued, and that was not allowed by Mr. Justice Osler at the end of the day. There's a lot of good law on that, particularly in the States, and you ought to have a look at that if you're into that bad faith kind of situation. So as we're moving along, along came OHIP, I think in the middle of the trial. I think Mr. Howie indicated somewhere along the line, by the way, he had a subrogated claim for OHIP, and we agreed that we would litigate that another time, and that was in excess of $500,000. So we had another trial, OHIP versus Travelers, as to whether or not we were obliged to indemnify them through their subrogation rights as they have. And the answer to that was no, we do not have to do that after a trial. Now this is a very important decision for two reasons. First of all, because I think it says to us that on first party coverage, there is no subrogation with OHIP. The reason being, and I commend the judgment to you, that the right of the insured is a right in contract, not a right in tort. OHIP picks up their rights only arising out of tort, and accordingly, they don't have a subrogation right because the statute doesn't give it to them. Now, there's that other decision that's here, Fitzpatrick's decision, which goes the other way in the sense of SCF 42, SCF 44 endorsements under insured coverage. I think there's now an argument can be made that it's a first party claim, it's an action in contract, and subrogation doesn't exist with OHIP. So keep that in mind as you deal with these things and the subrogation problem. Now that's the first thing that came out of the OHIP case. The second thing, just wait till I have a little water, is that during this whole saga to date, I had been losing and paying costs, and we went to the OHIP matter, and that lasted, I think, a couple days. Can't remember now. And my principals were exposed to $500,000, and we won. First time we won in this case. No costs. Judge said it's a novel, new point. There should be no orders to costs. So, in the third party proceedings that we just got, we did get costs. So my track record is intact right to this moment. I think there's an interesting argument I made in that case that I'm going to trade with you. The plaintiff sued in Michigan tortiously. The case was settled for, I think it was $1 million tortiously because it's just general damages. And it was structured, let's say it's $1.5 million Canadian dollars. I argued here, and then they sued over here on the no fault. I said, that's forum shopping. You can't go and do that. You have deprived me, my people, of an advantage here, in that there is a policy limit here of $200,000 on general damages. If the plaintiff recovered $1.5 million, then the balance over the $200,000 must be for other economic factors, such as the one that the plaintiff is now pursuing. Accordingly, I should get credit for everything over and above the $200,000, which our court here is stuck with as a limit. I thought that was a brilliant argument, that you can't go forum shopping, go over to Michigan, take your best bite over there, get $1 million general damages, and then come back here and say, and I want you to pay the no-fault benefits, which are very extensive here, because I say that's foreign shopping, and if you had done it here, you have taken away from me a benefit by going to Michigan that I would have had you litigated both parts of that in Ontario. I can tell you that my argument was long and lengthy, with lots of supporting material, and I could not keep Ken Howie awake during the argument. He sat there and had a snooze and got up and said, that's nonsense. Unfortunately, Mr. Justice Osler agreed with him. And he agreed with him on the simple proposition that you shouldn't have filed the certificate in Michigan if you didn't want to have to pay on the Michigan scale. I think that's right, but I think the principle is still a very sound principle. So the OHIP matter is a matter of some concern. And you should look at that. You should look at that trial decision for some inventive ideas that the plaintiff put forward in respect of damages and what you can prove and what you can collect, and what our courts are very liable to do with that sort of thing. Now, all of that has nothing to do, I guess, with my topic. Is that right? And I'm going to just refer you to the material that you have in front of you in respect of those two items. There's not very much that I can tell you about. Pardon? Oh, I've got 10 minutes. Well, I can talk to you more about the Travers End because I have 10 minutes, and then let me take you to the commencement of this. Of the paper, and I hope we're all working on the same pages here. The SCF 27 endorsement. This is the kind of thing that you use when you go to Florida and you rent a car. Be very careful you're not renting a car down there and making a deal with a lot of friends you're going to share the cost, because if it has a commercial overtone to it, there may be no coverage. Be very careful, when you talk to your agent about this, that you know the limits of the coverage, because it's first-party coverage for collision. Most of these endorsements are for $15,000. So be very careful about that, because most cars you rent are worth a lot more than that. So you may think you have coverage, and you do not. The second thing is you have to be very careful not to have other members of your household renting cars like you are in Florida at the same time, because you're only allowed one at a time. You have to be very careful not to rent it in excess of 30 days, or your endorsement doesn't apply. So the document is very straightforward. You should have a look at it, and you should have a look at the exclusions. Those are the highlights of what the problem areas are. I'm told in Mexico, as you know, our policy doesn't go beyond Canada and the United States. In Mexico, they don't recognize North American insurance policies. You have to buy it at the border and get that kind of insurance. My recommendation is that you don't drive in Mexico at all. And if you do drive over there, buy every kind of insurance that you can get, and I'm told you can buy it at the border going through. So, those are some of the problems that you have in respect of these endorsements. The other thing I'd like to just touch on is the $1 million coverage that you have, and your policy says you have $1 million coverage, and you get into Michigan and you have an accident and there's a $2 million claim. Along comes your insurer and says, you have $1 million coverage, but we pay in Canadian dollars. So you really only have $850,000 US dollars, and we don't pay, and our limits are then $850,000. In the state of Michigan, for example, their policies are, if it's a $1 million policy, $1 million plus prejudgment interest and costs. Costs are of no consequence over there. Ours is reversed. So you may be over there with a $2 million judgment against you, and you only have $750,000 worth of actual American dollars to pay that. That's now been decided. There's a case that says that the Canadian policy pays in Canadian dollars, and it's something that you should be concerned about if you're driving or advising people who are traveling in the United States. That's all I have to say to you here, except that Wendell Wigle is still my father. Just wait till I get my...
Al, it's true, I didn't know that Ted Racklin was involved in that case, but now I understand why he spent $150 on you in Hong Kong. When Al started these cases, he had a full head of hair, and you'll see what's happened as a result of the trials. Now, our next speaker is Ken Howie, in trying to briefly introduce Ken, I thought the easiest thing to do is to tell you what organizations he has not been the president of, but I was unable to find any. So other than to say that although he has been the president of and is a member of almost every significant legal association in Canada and the United States, he also is an honorary life member of the Ontario Insurance Adjusters Association. Ken obviously has taken so much money from the insurance adjusters that they thought that they should acknowledge it in some way. Without any further ado, I'll ask Ken to discuss with you the approach to settlement of automobile accident claims from the plaintiff's perspective.
Thank you, Mr. Chairman, ladies and gentlemen. I wasn't going to say anything about the McDonald case, but the one thing to say to you is my friend at the end of the table with whom I've had an awful lot of fights and an awful lot of fun over the years, particularly in the McDonald case, has had the misfortune, as he's told you, of not being able to get anything reported that he won, and he's had all of them reported. He left out the 2 actions in Michigan, which he also lost, which had reference to this case. And the truth of the matter is, it's a ton of money. We sorted it out that probably the ultimate amount of money that Travelers is going to pay will be at least in excess of $10 million in 1988 or 1987 dollars. But in fact, he told me when the day was done he was going to win, and I don't know whether you understand what he told you at the end, and that is he's won. Travelers was only going to pay $250,000. Now, I've spoken to the editors of the Ontario reports to try and ensure that that decision is not reported. That case, I'm not going to talk about that case. If I'm a little bit uncertain about what I'm doing this morning, you'll have to forgive me. I'm in the middle of a trial that's been going on all week, and it's a big case, and Peter Webb was involved in it, but I settled with him. And I think because I'm going to be talking about settling cases, I'm going to take 1 second and tell you about it. It's simply a case in which Tim Fellows is defending now the major aspect. He has a $1 million policy. We offered to settle for the $1 million just after the beginning of the trial on his policy. And we finished the trial yesterday. Tim Fellows is arguing this morning, it's the last argument, and Mr. Justice O'Brien was going to give judgment at 11:30, all right? I can't be there because I'm here, and I told Wendell last night I didn't know how I could be, but as I was sitting there 5 minutes ago, one of my associates rushed in and handed me a piece of paper in which instantly before Mr. Justice O'Brien is giving judgment, they accept our offer to settle for the policy. Believe it or not.
First class.
So I've said, for God's sake, don't go on with the trial. Ask Mr. Justice O'Brien to hold off until 3 o'clock when I'm finished here, and I can go and see what we can do about that acceptance of the offer that's just been made. It leads into the subject. One of the things that Mr. Cameron, the next speaker, and I talked about when we were trying to Wendell's putting this panel together, was the issue about what's going to happen with respect to the industry, what's going to happen with respect to automobile insurance, and none of you can avoid reading the papers with all the wild talk about public automobile insurance, the revival of the no-fault scheme, enormously increasing premiums, and the possibility of enormously increasing premiums, and the issue about how the money that's available for the victims is being squandered among the lawyers. There is, of course, some truth in that. And if I had a pitch to make to you today, and I do it deliberately, partly because of the seminar that I know some of you attended some weeks ago, Canadian Institute seminar, where some enormously able lawyers talked to you about the methods that they use to, in effect, avoid negotiating settlements in the early stages and the later stages. And the methods that they use to ensure that their clients, in their view, are fairly treated. I think what concerns me and should concern both the profession and the industry is the fact that the combination of the cost and delay in the failure to negotiate is significant. And in my view, it's fair to say that if even half the cases in which lawyers are retained either went to trial or got close to trial, there's no way that our overburdened judicial system can stand the weight. And there is, therefore, in my view, an extremely heavy duty on the part of both lawyers and insurers to settle their cases as early and as cheaply as they can. Now, I've said in my paper, cheaply doesn't mean for less than they're worth. Cheaply simply means in terms of the cost of these cases to the administration of justice. Yesterday I had a press conference in the middle of this trial to present the Canadian Bar Association's major proposals for court reform in this province. And part of the function of that is to attempt to fit the system into the enormous burden of work that there is. And if the automobile cases, if I can just pick that bunch, but if the automobile cases are going to be a significant factor with respect to the administration of justice, because of the failure of lawyers and insurers to settle their cases early in terms of the court process and reasonably in terms of the cost to the litigants, that is the fees that the insurers have to pay to the lawyers, both their own lawyers and to the plaintiffs, then there will be the best argument possible for removing automobile cases from the courts, removing automobile cases from the luxury that we presently have, which all of us, certainly all the lawyers that are here, would like to maintain, and that is the tailoring of the damages of each victim to the particular victim, because that's going to be a casualty of any new system which removes the cases from access to the courts. Well then, enough preaching, but I feel so strongly about that that I thought I'd start out by telling you that. If you're going to look at my paper, I'm going to run through some of these things for fun. I asked a bunch of questions at the beginning, and the only reason I asked those questions is that my experience has been that lawyers, I've seen the lawyers, and some of them in my own office, particularly the juniors who become enormously enthusiastic, who in effect may take these attitudes towards the settlement of their cases. And that first one is a common one. That is, the junior comes into me and says, I've persuaded the adjuster to pay $15,000 for this whiplash, he, all right? Meaning, I know that the case is only worth about $10,000 and I persuaded the adjuster to pay $15,000. And you can imagine, you wouldn't believe my reaction, and that is that guy's going to hate you for the rest of your life because he's going to go back and report that he agreed to pay $15,000, and his claims manager, his claims examiner is going to jump all over him and say, you're crazy. Whether it's settled or not doesn't matter. If that's the objective that the lawyer has, I say to you, I think that's wrong. I think the objective of the lawyer will come to that in a few minutes. The next part is it as much money as you can get for your client without getting him involved in a lawsuit. Well, that's wrong too, because if the situation is that the case deserves to be litigated because the insurer won't pay sufficient money, then the answer is the case should be litigated. That's all there is to it. Is it, well, the next one, of course, is a favorite for the lawyers, is it to obtain the largest fee possible out of the case with the minimum amount of work? You and I, certainly the people here from the industry, know those lawyers extremely well. Is it to establish new law on the assessment of this type of damage? Now we're getting into a different area. Now we're getting into the area where the lawyer has a secondary purpose to the case. That is, he has something which he wants to accomplish, which may or may not fit into the best interests of his client. I ask the question, is it proper to do that? Is it to make the insurance company pay to make up for the one you just lost? Well, I'm more sympathetic to that situation since I lose enough cases. But again, the issue becomes the client's best interest. Is it to persuade your client to go to trial in the case to get what you feel she's entitled to, although she very badly wants to settle the case for what has been offered and doesn't want to go to court? This is the situation where the lawyer says, I know what your best interests are better than you do, and therefore should that be the way in which the lawyer should govern what he does with respect to the issue of settlement in that situation. Well, then finally, is it to fight this case out because you've been settling too many cases with this insurance company whose adjuster was in fact overheard to say about you, just wait long enough, old Ken always settles, all right? Now, that hits very close to home because that's what happened to me in the middle of a case where the lawyer who was co-defending told me that that's what the adjuster for the insurer had said. Now, the fact we did finish the case, and it went on to in fact, the case was called Franco versus Wolf, and it went to trial and it went to the Court of Appeal, but we couldn't settle it anyway, I'll tell you that. But that's the kind of thing that shouldn't govern. And finally, I say, is it to try to obtain for your client everything to which reasonably and fairly he or she is entitled the day before yesterday, meaning as early as possible for a reasonable fee? Well, I'll leave it to you to make that decision. To my mind, the next part I've dealt with are simply principles, and they are perhaps, at least as far as I'm concerned, worth mentioning. First, the client's best interests rather than the lawyer's are always paramount when it comes to settlement. The lawyer's belief in the client's best interests often vary from those of the client. So it's got to be, a lawyer has to be sensitive to listen to the client and to figure out what the client's best interests are rather than what the lawyer feels the client's best interests should be. And then the true settlement value of the case often lies in time as much as in quantity. These days, I'm telling my clients, and I suspect those of you that handle plaintiff's cases are saying to your clients, if the case is a serious case in any way, how long will it take? And the answer is, if the case has to go to trial, probably 4 years. And if it goes to appeal, probably 6 years. And any lawyer that misleads his client as to the length of time that's involved is being unfair. And so, as I've said, it may very well be that $5,000 is far more valuable to a particular client today than $10,000 4 years from now. Again, I've said that the amount of settlement, really, in the final analysis is the client's valuation. Another way of putting that is that the settlement value of the case is what your client is prepared to accept that the insurer is prepared to pay. It may not be what the case is worth. It may have little, in some cases, to do with that. Well, I've gone on from that point. Have I got any more time?
Sure.
I've then gone ahead to get down to some nuts and bolts that I think are kind of fun. My experience is there are some lawyers who do refuse to negotiate with the insurance companies. All I can say to you is that those that refuse to negotiate with some safeguards that I discuss a little later on are asking for the loss of this business. Now, nobody in the world cares whether the lawyers lose this business, and nobody cares whether the insurance companies lose this business. What the principle is that I think that you should be preaching is that we sincerely believe that victims should have the right to access to the courts to ensure, in the final analysis, if the case cannot be settled, that they get tailored for them an appropriate and proper assessment of damages. So the lawyers, in my respectful view, who refuse to negotiate because they refuse to negotiate are running the risk of impairing our entire system. Now, that doesn't mean that you want to negotiate with every insurer. And I must admit there are 2 insurance companies, whose names I won't use, where from my experience I know that it is a total waste of my time to negotiate. That is, there is no way from experience that insurer will ever pay more than 50% of even what I think the case is worth. And the result is that I have no hesitation in that situation of going ahead with the lawsuit, not because I want to go ahead with the lawsuit, but partly because when you're initially retained in a case, and the insurance companies sometimes I don't think recognize this, but if you're retained in a case of any significance, it ordinarily will take you a minimum of 6 months, often a year, to be able to develop firm prognoses with respect to the future. Obviously, until you've got firm prognoses in the case of personal injury or issues with respect to future economic loss, and you've developed that evidence, then it would be grossly unfair to a client to attempt to negotiate a settlement unless there's some urgency about the 90-year-old is going to die in 6 months, that kind of thing. The result of that is that if you're going to negotiate with the insurer, you're going to have to wait 6 months, a year. So the position I take in many of those cases is if it's a case where I know it's going to take 6 months or a year, and I'm pessimistic about the prospect of being able to settle the case, in that situation, surely it's legitimate to go ahead with the lawsuit immediately. I appreciate what the consequences are to the insurer, but the result is the client doesn't want to wait 5 or 6 years to have the case completed if it ultimately cannot be settled. And you're toying with the client's time to completion. And more, as our courts become more clogged and the delays in being able to get cases to trial become longer and longer, I'm getting people who are saying to me, Mr. Howie, I really don't care at this point. Settle my bloody case. It's gone on for 3.5 years, and I don't care that we're not going to get enough. Settle the damn case. So the result is you've got to be very sensitive to how fast you can push the case. You should try to negotiate, obviously. Well, there are some safeguards I want to talk to you about just for a moment, which lawyers should consider in trying to protect their clients' best interests. And really they are two. The first one is if you're going to give up your medical reports, for example, and you're going to give up your out-of-pocket expenses as the list so that the insurer in the early stages or even as you go along is fully aware of all the information upon which the assessment ultimately will be based. Is there some disability that you thereby create upon your client? And the answer is there may well be. And really there are two things. The first is advance payments. And I think there's some misunderstanding about this. I have lawyers in my own office who once in a while will say to me, my God, I negotiated with the insurer and those beggars promptly sent me over $20,000. As far as I'm concerned, I'm not quite sure what their problem is. I know what they think it is, and that is the heart's been cut out of the lawsuit by the advance payment. But surely, on balance, the best interests of the client involve getting for them as fast as you can, whatever you can get for them. So that as far as I'm concerned, this is me speaking. I know some other lawyers take different views. I won't say to the insurer, if I negotiate, if I provide you with all this information, will you agree that you'll not make an advance payment? I believe that's counterproductive. The same thing may not be true with respect to offers to settle or even payments into court, which, by the way, are still alive, although really no longer used. It is legitimate, perfectly legitimate in my view, for the solicitor to demand, if you wish, that if he's going to provide all the information and if he's going to negotiate, that the insurer agrees that it will not make a formal offer to settle until some stage. And the stage ordinarily is, if lawyers ask for it, is until the action's been set down for trial or until the examinations for discovery have been completed. In effect, the lawyer doesn't want to be, or if you like, the client, and therefore the lawyer in many respects, doesn't want to be penalized with respect to costs because he's given the insurer the ammunition to make an astute offer to settle. What's more important, of course, is that an insurer making an astute offer to settle very early in the proceedings exposes the client to significant risk. That is, the case may be worth $15,000 to $20,000. Maybe it's worth 10 to 20, really, and you want $20,000. and the insurer wants to pay 12, and you say, no, we'd take 15, but we wouldn't take 12. And they say, no, we won't pay you 15, here's an offer to settle at 12. Now the risk is, if you go on with the case and it is 12 or slightly less than 12, your client is not only going to have to pay your entire bill for the lawsuit, but is going to have to pay the insurer's costs as well. So to protect your client reasonably in that situation, I think it's quite realistic to ask or demand, if you wish, that the insurer will not make an offer to settle until that time. What always confuses me is the odd insurer that says, no, we never agree to those things, and I don't understand what disadvantage the insurer suffers. Because if they say no, the answer is, fine, we'll go ahead with the lawsuit. You carry on with the lawsuit, eventually the insurer gets the information, then makes the offer to settle, but what the hell, why did you do that? Why didn't you agree and get the case settled, hopefully get it settled at that stage? All right. Well, then, I then talk about where should negotiations. I had some fun with this. I used to, Wendell, Wigle, and a bunch of us up here have taught in bar admission for years and years and years. And we taught trial practice. And one of the things we dealt with were settlement negotiations. So I used to have great fun. I'd have these 15 or 20 young, about-to-be lawyers, and I'd say to them, now, if you're going to negotiate, should you go to the adjuster's office or should he go to yours? And they say, oh, well, of course he comes to my office. And they always said that every year. And I would say, well, why? And they said, well, we're professionals. We're lawyers. And, of course, it's great fun to prick that kind of a balloon and tell them that if they practice for 20 years, some of them will be as professional as the adjusters that they're dealing with. And that always upset them. So I said, you really should try, if you have any brains, offer to go to the adjuster's office. And they said, well, they hadn't thought of that, but the answer is, well, all right, we'll, okay, that's fine. And then, of course, they suggested to go to the adjuster's office, and the adjuster's embarrassed. That's been my experience. Oh, no, 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 I'll come to your office. And I finally figured it out. I think what it is most lawyers have private offices. And the answer is it's a place that you can get together without a lot of interference. And I have the feeling, I may be wrong, that maybe the adjuster has a desk in a room that's got a bunch of people, and therefore he'd really rather come to your office than you go to his. But it just seems to me, if you're lawyers, for God's sake, treat the people in the insurance industry as professionals, because they're every bit as professional. Most of them have far more experience, far more expertise than the average lawyer. Certainly far more expertise than the average lawyer they're negotiating with. Well, then, another issue that seems important to me is these are all psychological matters. But if you're a lawyer, for heaven's sake, don't tell your client what you think the case is worth before you've done the negotiations. I don't know how, I can't think of a worse way for a lawyer to get into trouble than to talk to a client about what his case is worth, unless he lies to him. Because I don't care what if the lawyer's got a certain amount of information, he's got his side of the case. Among other things, with respect to most of us, most of the people you're negotiating with, they haven't got a clue what the case is worth. They may go and talk to somebody, but they not only haven't got a clue, they really don't have much faith in the opinion that they do have. But if you go to a client and you say to the client, or the client wants to know, which is often what happens, how much is my case worth? I love the quadriplegic case that comes into my office and the guy says, okay, now I want to know how much is this case worth? It happened yesterday. Well, now, come on, you've got to be kidding. So I think the answer in that situation is, in terms of what you say to a client, it's only one thing, and that is, you should have no respect for me if I had an opinion at this time as to what your case is worth. There's no way you can have an opinion at that time. Not only that, but the other thing I think to say to a client is there are two sides to the case. You've told me about your side, and I've dug up these medical reports and the hospital records and so on, and I have a vague idea, but the answer is until I've heard the other side of the case, I won't have an opinion. So my own view is you're crazy as a lawyer if you try to get, if you work out or try to work out with your client in advance of the negotiations what the case may be worth. Still on the- No? All right. Perhaps I can finish by saying, dealt with costs, which are kind of fun, but the last thing I want to talk about just for a second is the method of your, if you're a lawyer, the method of your preparation. We give lectures, we have programs about how to prepare a case, but there isn't any doubt that unless your client is in a dreadful hurry, you've got to prepare the case adequately, and the preparation involves, as we all know, enough investigation. It reminds me of a case I had some years ago where a junior was doing the work, and what happened was it was a straight rear-end collision, and I said to the junior, would you go ahead and get it investigated? Now what I meant was, would you get the police report, all right? The next thing I had was a $4,000 bill for a profile of the road, all right? So the answer is, you obviously tailor the investigation to what the problem is, but the answer is get enough investigation done to be able to establish the liability to your satisfaction. That's what matters, whether it's split or what it is. And obviously you've got to develop the medical evidence and the paper evidence, that is the out-of-pocket expenses, lost income, and the supporting documentation with respect to all of that, in order to be able to prove it, and prove it quickly, and not leave a bunch of loose ends when you come to negotiate. And when you've got all that, there are issues about whether you should give it to the insurance company first. I hate doing that because I know what happens back at the insurance company. They read it all, then the first guy puts a price tag on it, the second guy says, oh, that's way too high, crosses that out, gets a lower figure, the third guy puts a lower figure on, and finally there's a meeting and they put the bottom figure on it, which is 4% of what the case is worth. I don't like doing that, but I'm too proud not to when the insurance company asks for it in advance, because they say we want to be able to try and negotiate it with you right at the time. That's legitimate. So the answer is fine, I'll give it to them. Some lawyers prefer not to. Often if I do give it to them, because I want to jump in first, and I made that point, if I am going to do that, I tell them what I think the general damages should be in the letter in which I sent the material to them. I'd far rather negotiate. I'll explain it to you best in this way. It's very hard to negotiate from 5 to 50. It's not that tough to negotiate from 100 down to 50. Anyway, thank you very much.
We're running a bit behind. We will not be taking a break this afternoon, and we'll move right from the speakers to our panel. So after any one of the speakers, would you please bring up any questions you may have written out? Our next speaker is Jim Cameron. Jim, when I first met him, was a junior adjuster with the Phoenix Assurance Company. He has now risen to the lofty heights of being a vice president of one of the Simmons Group companies. He is the president of the Insurance Adjusters Association, has given lectures on adjusting and related matters to many groups, and has written articles that have been published in many insurance-related journals. He has the courage to come and speak to a group of lawyers following Ken Howie's comments on how a plaintiff's lawyer should approach settlement. As a counterpoint, Jim will enlighten you as to the insurer's or the adjuster's perspective of settlement of claims. Jim.
Thank you, Wendell. When I was first asked to speak here, I noticed that I was sandwiched in between Ken Howie and Mr. Justice Coulter Osborne. And that reminded me of a true story involving entertainer Jerry Lee Lewis back in the 60s. At that time, when they staged concerts, they had a number of performers, unlike today, and it was tradition to have the most noted performer or the biggest star close the show. Jerry Lee Lewis was at this particular show, and Chuck Berry was also performing. And the promoters insisted that Chuck Berry go last. Jerry Lee Lewis didn't like this idea, and in his typical style, he decided to go on in any event and have a little trick in store for Chuck Berry. He was playing a couple of tunes. He finished with his #1 hit called Great Balls of Fire. He'd arranged for some stagehands to pour some gasoline on his piano, and he set it ablaze and finished the number with the piano totally engulfed in flames. The audience were in absolute frenzy. He walked off the stage with stagehands running around with fire extinguishers in total confusion and said to Chuck Berry, "You're on." However, after hearing Ken Howie, and I should tell you that the written paper here was prepared some weeks ago, I first saw Ken Howie's paper yesterday. I read it and I thought, he's stolen my thunder. I agree with almost everything he said. So I could have made it quick before lunch and said I agree with Ken Howie. However, I'm not going to quite let him get away with that. I'm going to talk about settlement practices from the adjuster's perspective. And I've tried to approach it from the needs of the client, who is, after all, what this is all about. I'll talk a bit about the notice letter, the reserving practices of insurers, medical reports, something about the Section B claim and the elements those play in settlement negotiations, and then I've gone into undertakings at some length, and we'll discuss, finally, actual settlement discussions, which are the fun part. My remarks, I should preface my remarks by saying that they are opinions and views that may not necessarily be shared by all my colleagues. Not all insurers or adjusters operate with the same philosophies and may not necessarily subscribe to the same theories. I've tried, however, to give general approaches that you will most likely encounter. And my remarks are directed to plaintiff's counsel because, after all, we all know that they are the problem. In looking at motor vehicle settlements from a duty to the client point of view, I don't propose to tell counsel what their duty is to their client. I suggest to you, however, that we, the plaintiff's bar, and the insurance industry cannot ignore the needs of the consumer, who is your client, our claimant. As I perceive them, the needs of the consumer, your client, are for you to protect his interests. The needs of the consumer, our claimant, are to receive fair compensation for their physical and emotional injuries. Any activity which delays the resolution promptly of your client's claim, I think, has to be scrutinized carefully to determine whether or not the negative effect of the delay is warranted given the injuries sustained by your client. In other words, the fairness of the compensation should be measured both in terms of adequacy and timeliness. In dealing with timeliness, the most important initial contact is the notice letter from plaintiff's counsel. You might find it strange that I would suggest to you that you get the notice letter out quickly, since it forms the starting point for prejudgment interest. However, I submit to you that it's much better for an insurer to receive a notice letter on a file promptly than to receive one 2 weeks prior to prescription on a claim they knew nothing about or from a claimant they didn't know existed. Once a demand letter is received, the insurer creates a claim file if one did not exist and must set a reserve. This reserve should be based on the ultimate probable cost of the claim when it is finally settled and include all legal and adjustment costs. In order to set an appropriate reserve, the insurer must have some details of your client's injuries. The insurer must know the expected duration and nature of disability and the effect on the earning capacity of your client. A plaintiff's counsel who refuses to divulge any information about his or her client until settlement negotiations begin several months or even years after the event is not doing a service to his client. Faced with a stone wall, the insurer or adjuster has little choice but to try and develop such information from other sources. Some of these other sources may include the use of a private investigator to investigate your client's employment history, investigate his neighbors, and even perhaps place your client under surveillance. Believe me, insurers have as much distaste for this process as you and your client do, particularly when the insurer has to pick up the tab. Why not divulge to the adjuster up front basic information on your client? This information should assist the insurer in setting the reserve at the time you first notify the insurer. The adjuster is not asking you to quantify your client's claim and fully expects that in respect to any estimates you give him of the extent of the injury or recovery periods, that these are merely estimates and you won't be held to them. The adjuster does expect you to know, and I think you should know, where your client works, how much money they make, what they actually do in their employment, and what family status they have in respect to FLA claims. I suggest to you that giving this information to the adjuster at the outset of the claim will help you to a speedier resolution of your client's claim. If your client received treatment after the accident at a hospital, the treatment records or admission records should be readily available and ordered immediately. These are invariably required in any event when you settle a case and are inexpensive and can form a quick synopsis of the injury to third-party and accident benefit insurers. Some counsel wait several months to obtain reports from attending physicians. There are plaintiffs' counsel, and there may be some in this room, who have admitted to a standard procedure of not requesting any medical reports or records until 18 months after the accident. I submit to you that this is hard to justify as being in their client's best interests. Even if your client has a severe injury and will require ongoing treatment for several months or remain disabled for several months, a report from the treating physicians within the first 3 months can be helpful for both sides in the assessment of the case. A word of caution about medical reports, however. Chiropractors' reports are viewed with some skepticism by the medical profession and hence by insurers and adjusters. A frank discussion with the adjuster prior to ordering a report from a chiropractor may help you assess its helpfulness in settling your claim. While there are, so that I don't run afoul of the Chiropractors College, I should qualify that remark, that while there are many excellent chiropractors who obtain good results for their clients, there are unfortunately still a few whose reports qualify for a Nobel Prize in fiction. I attended a seminar which was referred to earlier in Mr. Howie's remarks, where a senior plaintiff's counsel told the audience that he demands full disclosure from the adjuster. At the same time, he said that he reserves the right to claim privilege on certain medical reports that he feels don't help his client. Full disclosure of medical reports to the adjuster enables the insurer to consider or reconsider any settlement offers or advance payments, which I'll get into later. Refusal or failure to disclose medical reports to adjusters could be met and should be met with the argument that until such reports are provided, the insurer cannot appreciate the significance and extent of your client's injury and therefore ought not to pay prejudgment interest on damages. The Section B claim has been canvassed earlier, and Mr. Justice Osborne alluded to it in his remarks. The only thing I can add is to make sure that you do claim those benefits, because the adjuster is going to want proof of either payment of the benefits or the fact that they were denied. Undertakings. This is an area that touches the hearts of a lot of adjusters, because nothing is more frustrated to an adjuster nothing was more frustrating, to an adjuster than to be faced with a series of undertakings to which he or she cannot commit. Failure to grant undertakings leads to an end to the negotiation process. You, as plaintiff's counsel, must keep a file open longer, spend more time on it than necessary, and of course the same is true for the insurer, who must spend more money than necessary and involve defense counsel. And with all due respect to the learned gentleman who appeared in the panel this morning and this afternoon, we don't like hiring these guys. It costs too much money. Undertakings to admit liability. Even in the most clear-cut situations involving rear-end collisions, the insurer will probably not admit liability. Most insurers steadfastly refuse to admit liability at any time in the proceedings except at the commencement of trial or in an appropriate case immediately prior to examination for discovery, just to avoid some problems in producing the insured. Even where liability is not an issue, the insurer will want to preserve the right to contest liability at trial in the event the claim cannot be settled and involves any number of traumatic neurosis, considerable subjective symptoms, extensive pre-existing history, any claims involving the use of a seatbelt or failure to use a seatbelt, and any claim where the policy limits may be exposed. Where the credibility of the plaintiff may be brought into question in respect to damages, to throw out the opportunity to further impinge credibility at trial in respect to the circumstances of a collision just does not make sense. If, however, you are successful in extracting an admission of liability from the insurer or his adjuster, the insurer should seek in return an undertaking from you not to amend the prayer for relief or to claim in excess of the policy limits. If the pleadings have not yet been served, the admission of liability by the insurer would be tantamount to giving a blank check in the hands of your client. It probably could be argued in either case that the admission of liability may have prejudiced an insured in respect to his position, his personal exposure in excess of the policy limits, and therefore subject the insurer to a potential bad faith action from his insured. At the preliminary settlement negotiation stage, an insurer generally does not know enough about your client's claim to ignore this possibility. The undertaking not to make any advance payments. Ken Howie says that he disagrees with seeking this undertaking, and so do I. The undertaking creates the most grief for adjusters and insurers. Most insurers will refuse to grant this undertaking under any circumstances. After all, the successful defense of a personal injury lawsuit is difficult enough without taking away what can be the most effective weapon in the defense arsenal. By denying your client the potential benefit of any money until the conclusion of settlement, which Ken Howie admits may take up to 4 years, is not, I submit, in your client's interests. Advance payments should in fact be requested from the adjuster, and your client's needs should be regularly assessed by you in anticipation of an appropriate payment from the defendant's insurers. Seeking an undertaking from an insurer to forego its statutory right and not pay advances under Section 224 of the Insurance Act forces the adjuster to go to his principals with a request which should be denied. At that point, unless you back down from the demand, the lawsuit continues without negotiation. The advance payment attacks the prejudgment interest component of the claim at any point in settlement. The offer to settle attacks your costs only in the event of trial. If you seek an undertaking not to make an offer to settle, I question why. If an offer to settle is so close to the value of your client's claim as you perceive it acting for your client, why would you not recommend it be accepted? If it is too low, it should not pose a serious threat. You, as plaintiff's counsel, should have enough confidence in your own assessment of the case that you do not require this undertaking. If, however, you still insist, then at least be prepared to give a reciprocal undertaking to the adjuster. By agreeing to not make an offer to settle on behalf of your client, you restore some element of fairness to the negotiation process and still preserve your costs. The undertaking to pay for medical reports. This undertaking is perhaps the most often sought and most often granted. Since the death knell of extra billing by the province's doctors, we have seen a marked increase in the fees charged by healthcare practitioners for their reports. Such fees are often demanded, as you know, prior to the report being released or within 30 days. Not only does your client have to adjust to cessation or reduction in his or her income as a result of the accident, they must also come up with several $100s to finance the lawsuit. The reasonable cost of medical reports is, as a disbursement, properly a part of costs, and if unpaid by the insurer, would not attract prejudgment interest. It is reasonable to ask for this undertaking, provided that you're prepared to disclose all medical reports to the adjuster, and provided that you don't send your client on the medical report shopping merry-go-round. There is another plaintiff's counsel who may be here, I haven't seen him, who openly admitted to an adjuster that now that they've given the undertaking, he's going to send his client, he named half a dozen different specialists. Some insurers limit this undertaking to reports from treating medical practitioners only, by inference eliminating chiropractic and other healthcare providers. In an appropriate case, however, the report of such providers may be helpful in negotiating settlement, and its cost may be picked up by the defendant insurer. Investigative treatment or diagnostic methods such as thermography should be pre-authorized by the insurer also if you expect the insurer to pick up the cost. Most of the adjusters in this room can tell you of numerous cases involving settlements with plaintiff counsel where the cost of medical reports equaled half of the general damage figure or more. In such cases, I question whether the best interests of your client are being served. Out of the total insurance settlement, what proportion of it is reaching the consumer? Unless you intend to try the case or feel that the client is not receiving appropriate treatment, even referral to an orthopedic surgeon for the sole purpose of obtaining a medical report may be an unnecessary expense. Properly written reports from the treating physicians are often more valuable for settlement purposes than the reports from such medical legal report factories. By all means, ask for the medical reports to be paid by the insurer on receipt, but be prepared to be reasonable in the selection of physicians you send your client to, and be prepared to release all medicals promptly to the adjuster. Settlement negotiations. Now that the adjuster has all your client's medical reports and has made advance payments to you, and the heart is taken out of your claim, as Ken Howie refers to, you feel it's time to settle. You invite the adjuster to your office, or you go to the adjuster's office And I'd like to say that Ken Howie should probably plan to spend a lot more time traveling now that he's announced that he will visit adjusters in their office. What do you have the adjuster present? Do you supply a number or try to extract one out of the adjuster? Some counsel play a little game that I call let's make a deal. This involves the lawyer and the adjuster both writing a number on a piece of paper, then exchanging papers. Settlement is usually somewhere behind door number 3, which is neither number. You should remember that the adjuster, given a proper time to review the medical reports, has a fairly accurate idea of what the claim is worth to settle. Any number that you put to the adjuster that is far in excess of the value of the claim will be recognized for exactly what it is. If you present your claim, your client's claim, in a forthright manner and are willing to negotiate, there is no reason why the claim shouldn't be settled. How you actually negotiate is really more a matter of style than substance. In conclusion, I'd like to say that negotiations towards settlement of an auto bodily injury claim should start the moment you, as plaintiff's counsel, acquire the file. Only through full disclosure and by not seeking unfair advantage through onerous undertakings will the tort system now in place work properly. The delivery of the product to the consumer, your client, should be timely and appropriate to compensate for their loss. The writing is on the wall that if the plaintiff's bar and the insurance industry cannot clean up their act, they will be cleaned up for them. Thank you.